As you are all aware, or in case some of you don't, or you are not aware, the Africa Law and Emerging Technology Policy Hackathon is being convened by the Data Science Law Lab, headed by Prof Chijioke Okorie. Could you please give her a round of applause? Thank you. The hackathon aims to engage law and technology policy to address African challenges and activate African solutions. The hackathon allows participants to work in teams to develop creative policy solutions to problems and use cases presented by diverse partners from academia, government, and industry. The theme for this year's policy hackathon is Artificial Intelligence in Public Administration. Across Africa and globally, national intellectual property offices have a statutory responsibility for administering various IP rights. By virtue of and in the course of performing their statutory duties, national IP offices are the custodian of valuable innovation data. However, a significant number of these offices across Africa grapple with two critical challenges: under-resourcefulness leading to inefficiency and untapped potential of large IP data for innovation. The teams were tasked with developing a comprehensive policy and implementation roadmap for a national government to strategically introduce AI tools into its IP office. So we want to thank all the teams for their submissions. And today, after the plenary address from Prof Okorie, we will take a few questions, if any, and then Zinzi would provide more context about this year's hackathon, after which the hackathon teams will present their solutions and receive feedback from the judges. Winners shall be announced at the end of the process, and Prof Okorie will inform us what comes next in terms of taking the winning solutions forward. On that note, I welcome the teams, the judges, and other guests present both in person and online. Thank you. I now invite Prof Chijioke Okorie, the Director of Data Science Law Lab, the Program Coordinator of UP's LLM in IP Law, and the convener of the Africa Law and Emerging Technologies Policy Hackathon for our plenary address. Thank you.
Good morning, everyone. What is going on? Why are you nervous? You've submitted you have to get behind what you submitted. Take it as it's done. You can't call it back. So let's have ginger. This is supposed to be interactive. When it's time for you to present now, and you come up here and you say, good morning, and everybody's looking at you. You see, that's not good. Okay, welcome everyone. And I want to start by saying thank you to my students for their wonderful submissions. But anyway, today we're not just celebrating the end of the competition. I think what we're doing more is the conclusion of a learning journey, but it's not really a conclusion. I think it's a massively significant stop to the journey, to our learning journey for this policy hackathon. So we started with a simple question. We said, if AI is reshaping every sector of public life in Africa, what should our laws and policies do about it? And in the context of this hackathon, the question we asked was a very focused question, a question that is also, I think, urgent. And we are asking, how should African national intellectual property offices that are the very custodian of innovation data, how should they harness AI responsibly to become more efficient, more insightful, and more equitable? And so I wanted to have this opportunity to explain why the hackathon exists, what it is designed to do, and what I believe it's already achieved, not just as a competition, but as a model for legal education and policy co-creation in Africa. So the first thing is to talk about the problem, a crisis in IP governance in Africa. Last year, there was a professor in India who wrote an article in a newspaper or a magazine called The Hindu. That article is titled "Building a Library of All the Books in the World." And in that piece, he described the structural strategy that is at the heart of global knowledge governance. And what he was saying was that despite all the technology that we have, there's no central digital library of all the books in the world. And it's not because the technology is not there. It's not because we don't have the technological capability, but because of one obstacle, and that's copyright law. That's his opinion. And then he described how AI companies, especially the big tech companies that we know, how they had to actually buy millions and millions of various books, remove the book covers, scan the books, and then use them to create a legal digital copy for AI training. And then he made the point that basically led to the challenge that we dealt with for this hackathon. The point that he made was that he said that if you look at the various public offices that handle printed materials, whether in South Africa, whether you talk about the government's printing press, where you have all the gazetted laws and publications coming from government, printed out and all that, there's usually a requirement for legal deposits where you actually have the physical copy deposited. Newspapers also have that obligation to provide a deposit or a printed copy to the national libraries, or its equivalent. And he was saying that this could be modernized and extended to build national digital libraries that would also power AI development. When we now bring that home to Africa, we look at our IP offices, whether it's the patent office, whether it's the trademark office, whether it's the same office that handles industrial design registration. And when you look at voluntary registration of copyright, right, you find that there's massive data available from all those activities. Just because the IP offices are doing their duties as a public office, they end up creating this infrastructure that could, revolutionize the way that we administer IP across Africa. So when you look at those IP offices, you see that they are not just passive repositories that are struggling to share knowledge. They are actually active administration that are struggling to process and manage and leverage the innovation data that they already hold. That's on one side. On the other side, you then look at the fact that we have a backlog of patent applications, delays in trademark registration, underutilization of copyright registration data. And these are not just inconveniences, they are barriers to entrepreneurship, to investment, to national economic development. And so the challenge for this hackathon, we identified two interlinked problems. Maybe I should now transform into a classroom environment and say, what are those problems? But the first thing we said that there's chronic under-resourcedness of African IP offices. And we those of us that are already in practice already can see those challenges. And that leads to inefficiency and frustration for innovators, for businesses. Imagine if a business wants to register a trademark and you tell them that it's going to take not less than 6 months. And they have a product maybe they want to launch. In as much as you want to blame the business and say, but you should have come all this while since you know that you want to register. But it should actually, happen quicker than that. The second problem that we identified was the untapped potential of the vast innovation data that these offices hold. And that's where you put on your, as a law student or as a lawyer, where you put on your transdisciplinary thinking cap, where you're saying every day that we go to the trademark office to register a trademark, there's a lot of information that we are providing about the business, about the sector. The class of the trademark registration would already point us in the direction of these are the kind of businesses that are seeing more trademark registration. These are the kind of businesses that are opposing more of trademark applications. These businesses in this sector try to register their trademarks in these particular classes. When you look at the various classes that you could register your trademark in. So you have all that information coming to the IP offices. And that's data, if you look at it from a data-driven innovation perspective. And so we looked at those two problems and we said, these data can inform national innovation strategy. It can identify emerging technology trends. It can highlight strategic gaps, not just in South Africa, but all over Africa. And so the hackathon this year focused on that theme. But broadly speaking, the Africa Law and Emerging Technologies Hackathon was something that I conceived because I believe that the solutions to Africa's AI governance challenges, and not just AI, any technology, has to be developed with Africans, by Africans, for Africans. And there is a persistent assumption that Africa is a monolith. So when I think there's this author who wrote a book and said, or a newspaper piece or something where he said, Africa is not a country. Because outside Africa, you hear all these references where they say, in Africa, we're going to do this in Africa. Africa is going to do this. But there are several countries in Africa. And each country has its own unique challenges. So our challenges as Africans can be similar, but each national context determines how we perceive the problems, how we feel the problems, and how we then conceive of solutions to those problems. And so for us, with the policy hackathon, the national context really matters. The institutional capacity will matter, the legal tradition will matter, the political economy, and the specific innovation landscape of each country will matter. So if you look at African countries, you will start to see that in some countries, this is the sector that is most thriving. In this other country, this is the sector that is most thriving. And governments need that kind of data to be able to make decisions about where to apply limited resources. So you don't have an abundance of resources, right? So you're going to have to make a decision and prioritize certain sectors. So if in South Africa, this is the specific problems that the country is facing, that's where resources should be targeted at. And you make that decision on the basis of data. You can't just say because, this is this, this is what I'm going to do. You have to make those decisions on the basis of data. So that's why the hackathon is structured as a co-creation exercise. So it will ask you as students to not just apply existing framework to African problems. You're going to need to engage with real challenges. You're going to engage with, partners, and you're going to develop original context-specific or context-sensitive policy solution. So this year's hackathon, we asked you to design a comprehensive policy and implementation roadmap for a national government to introduce AI into its office. The roadmap had to address 3 dimensions: operational efficiency through AI-powered tools, strategic intelligence through AI-driven data analytics, and then an ethical and governance framework to ensure responsible, transparent, accountable deployment. Then it also required you to come up with a stakeholder engagement plan. Why? Because policy solutions have to anticipate resistance. You might design something and feel like this is really nice. Everybody who won't like this thing? And someone comes with a genuine reason why this doesn't make sense. Or maybe it doesn't make sense not because of the content of the idea itself, but because of the timing or because of how you're prioritizing where to start first. So if you come in a country like South Africa, for example, and you design a specific policy solution as a government. And then you say, well, because everybody within and outside South Africa knows Johannesburg, we're going to start with Johannesburg. Meanwhile, the people that are most acutely affected by that problem is in maybe Limpopo, for example. So you have to be able to explain your decision to the people that will be affected or will be most affected by the decisions that you are making. If we wanted to solve a water problem in Gauteng, where should we start? I did not say it, but anyway, I did not say it, and I won't agree or disagree. I'm being a lawyer about it. But the point is that when you come up with a plan, when you come up with a policy, you have to carry stakeholders along. You have to engage them. If you don't engage them and they don't feel that they are part of the decision, they will not support you. And you need support. Otherwise, your solution, even if it's fantastic, will fail. And that's why we wanted for this year to consider those two aspects. So the hackathon really, I'm praising myself now, but I think it models good policy co-creation, what it should look like, because it's multi-stakeholder, it's multidisciplinary, it's grounded in real institutional context, and it's sensitive to power dynamics. And I think it's also accountable to the people that it affects. I want to talk about the teaching and learning aspect of the policy hackathon, because you know, when I say you now, I mean my students now. You know that there's more than just hackathon at stake, right? Your marks, your grades are at stake, right? So it's not, so the hackathon is not an extracurricular activity. It's an assessed component of our IGZ 802 module, which is our intellectual property and innovation and new technologies module in our Masters in Intellectual Property Law program. And so it's designed to be quite specific. So we want to train the next generation of IP lawyers to be policy thinkers, not just legal technicians or legal practitioners, full stop. And I'm using that term, I can use that term without feeling a type of way about it, because I think that a lawyer that is trained to apply the law just as it is will not go further than a lawyer who also appreciates the policy dimensions of decisions. And so you need to then move from just advising clients on compliance, on drafting contracts, filing application, arguing cases, interpreting statutes, and things like that. That's not just sufficient, because a policy thinker will ask a different kind of question. Why does this law exist? What problems was this law designed to solve? Has it succeeded? If it has not, what should be changed and how? Who benefits from the current arrangements? Who is disadvantaged? What are the distributional consequences of different regulatory choices? Because you have to make hard decisions and you have to make them with data. So these are the questions that the hackathon forces students to confront. And so when you are asked to design an AI governance framework for an IP office, you can't answer by just citing a statute, right? The statute is your starting point, where you say, this is the IP office that is by statute authorized to administer IP, to manage IP, to register specific IP rights. But you can't just stop there. You need to then start thinking about institutional design. You need to start thinking about incentive structures, about the ethics of AI decision-making. Because if you deny my trademark application or my patent application and I find out that you relied on AI, I will have questions, right? I'm going to ask, was there a human in the loop? Did you check to the decision to know whether, you agree with it? If the decision doesn't favor me, I might also have questions around why did it not favor me? What did you take into consideration in making your decision? So those are the kind of things that are not specifically provided for in a given statute, but something that you need to think about as a public officer or as a public office. So I think that's the thing that takes the policy hackathon from an extracurricular activity to just to more than, to teaching and learning, to more than what we can see. Is it in our spiritual thing, more than what we can see with the physical eye? Anyway, you had to respond to the hard questions and to persuade the judges that your proposed AI tools are not just technically plausible or reasonable, but they are ethically sound as well. And that's the kind of learning that can't happen just in the lecture room. It requires discomfort of working under constraints. It requires you working on a problem that does not have a single right answer. And I want to acknowledge the work that you've done, all of you, and the intellectual undertaking that is this whole exercise. So well done to all of you. And I think to round off, this year's hackathon is the third iteration. So we started in 2024. So we did in 2024, 2025, and this is the third year. And every year, I think we learn something important about the quality of student engagement, about the real world relevance of the challenges that we set, and about the policy gaps that remain to be addressed. So thank you to everyone. Thank you for all the hard work. The judges' feedback will tell you more about how you fared. But let me close by still referring to the article that Professor Ali wrote in the Hindu, where he said that the surest thing that any country can do to improve its human capital is to provide unhindered access to knowledge. The same logic applies, I think, to innovation governance. The surest thing any African country can do to support its innovators, its entrepreneurs, its creators, is to build IP institutions that work. The institutions that process our applications efficiently, that make their data accessible and useful, and that are trusted by the public that they serve. I think that AI can help to build that kind of institution, but only if the legal and policy frameworks governing its use are designed with care, with ethics, and with deep understanding of the African context. And that's precisely what this hackathon set out to do. So today we'll see the results, we'll see how you thought about it. Thank you for the work you've done. Whatever the judges decide, the thinking that you've done and the arguments you've made and the solutions that you've imagined matter. So to our judges, thank you for your time, your expertise, and your commitment to this enterprise. And to everyone, I think the challenge of governing AI in the public interest is one of the defining policy challenges of our generation, and we all need to be equal to it. Thank you. This is the point where you can. So one of the things we're done, I'm done with my speech and my address. But one of the things that we also wanted to do today is to celebrate World Intellectual Property Day. Right. So every year, the World Intellectual Property Organization comes up with a theme. They come up with a theme to mark intellectual property. And so we have World Intellectual Property Day every 26th of April. But between that 26th of April and 2 weeks following from that, various organizations have various things that they do to mark World Intellectual Property Day. And for me, as an IP, am I a self-acclaimed IP expert? I'm not. People also acclaim me, so yeah. But we always do something to mark World Intellectual Property Day. And for me, it's not that we just do something so that we can tick the box and say we're marking World IP Day. I always want to use it as a teaching and learning opportunity for my students, but I also want to use it as a way to reflect on intellectual property. In many ways, and sometimes we find that intellectual property, depending on who is speaking, can get a bad rep or it can get a good rep. But I think that intellectual property deserves to be celebrated because it's the best legal field that you can be in, that you can imagine. Why? Because it cuts across various aspects of life, right? There's nothing that we do every day that does not involve one form of intellectual property or not, right? Because we are human beings and we are at our core imaginative, and we create and we use our minds and intellectual capabilities to come up with ideas, to come up with things, and that's the domain of intellectual property. But this year, the theme that WIPO, that's the World Intellectual Property Organization, chose is IP and sports, ready, set, innovate. And it's a reminder that IP is not an abstraction, that it's in the boots that is worn by a footballer, for example, the broadcast rights that carry the match into a living room in whatever part of the world that you find yourself in, the patents behind the performance tracking wearable, the trademark that makes a sports brand instantly recognizable in Pretoria, for example. So sports is one of the most commercially and culturally dense intersection of IP rights. So that's why we celebrate, we celebrate IP. You remember that we had Modise Sefume from Sefume Attorneys, who delivered a lecture on the intersection of IP and sports and entertainment. So I'm going to ask questions from the lectures. But we heard from him, and he gave us, conceptual grounding. But we also want to now put that into practice. So we had Refiloe, who was not able to join in the policy hackathon, but I said, wouldn't it be nice for you to also have the applied learning that the rest of, the students enjoyed? So she was given a different challenge to design a simulated IP consultation in the sports sector. Is it more difficult than the policy hackathon, or is the same? Thank you. So she was asked to do that, working across disciplines, constructing real-world client scenarios, and then she will produce it into a professional advisory memorandum. So her work has been reviewed by 2 expert practitioners. So there's one from IP law practice and one who brings a perspective that we don't often hear in a law school setting. And that's someone who actually runs sports at an institutional level. So it is my privilege and honor to welcome Stephen Ball, who is the director of Talk Sports. We're supposed to be clapping. And also the acting CEO of the High Performance Center, that's HPC. So Stephen will say a lot of things. I don't know what he was going to say. But I think what he would talk to us about, I think it's a fitting way to mark World IP Day. And I think also that we will benefit from the feedback that he will give to Refiloe, and also to just even speak to us about what the sports sector need from IP lawyers so that we don't make mistakes. I'm going to stop talking. Stephen, the floor is yours. Yes.
Good morning, ladies and gentlemen. I must say it feels a bit weird. I feel a little bit like Stevie Wonder at a Britney Spears concert. I know nothing about law, but I'm going to try and share a little bit of some lived experiences in my world. And hopefully that will just challenge our thinking. I think the point was made a bit earlier that the intersection of law and sport is so massive. And we're seeing it with also in the data space, the intersection of data and sport is huge. Whether it be just in terms of your wearable technologies that is happening and things like that, to a simple thing like athletes logging their training data or their feelings on how they are feeling on a day-to-day basis, and that gets used to derive how coaches coach them. So I think from my side, thank you for pulling me in on this event. It's quite exciting. Maybe some comments that I made around Refiloe, your project. And again, I'm no specialist, but I think you touch on two very key elements there that are in the sports space. The one is the whole conversation about the wearable technologies, and that is a massive industry. It is a massive multi-billion-dollar industry. If you go onto any platform right now and you go and you just choose a smartwatch, if you go and just go onto Amazon and go onto Amazon.com and you say, let me find a wearable smartwatch, you'll be surprised how many are there. So I think the key that you touch on there is a critical one. The second one that you touch on is the engagement with the professional athlete and their brand. And that, again, is often what people think. They have brands, right? The question, I guess, is really, how much is my brand worth? Is it worth anything, or is it worth something really massive? So some of the things that stood out for me was the concept of the client intending to monetize. Because at the end of the day, people are looking for value, right? And I guess we all measure value in different ways. I might measure value in personal appearance. I might measure value in what it does to my pocket. I might measure value what it does into the performance of the team. In this case, this athlete, for example, that you interviewed, and that they talk about the monetizing, to be able to take it to a point where they could sell how they train. So I think the challenges that you sit with there is there's a lot of people believing the same thing in the market. And I think our challenge in our world, whether you're in the law space, in the sports space, whatever it is sifting through the noise of, do you actually have value? So in our world of sport, and I didn't maybe see it come through enough, but is that critical conversation around being a rights holder. And I wrote a few questions here. Who owns the rights? What are they? What can we actually use of those rights? What can we give away? What can we truly give away? I'll explain what I mean by that. What value do they truly actually have? And then, are we going to give it away for benefit or not? And that's maybe something that I think in this space is, when you are dealing with athletes and sports and whatever, is how do you bring those questions into the rights holder conversation? Now, the rights holders could be me in my personal capacity. It could be me as a sporting organization. So there's a reason I wore specifically besides the cold, I wore my stripe today, because tux and our stripe is our thing, right? That's one of our things that we like to associate with. So there's a certain, in this case, a brand association, and does that have value in the question? I think the other question is, on the other end of the question is, well, who wants a piece of that pie? Because it's fine for me to say I would like to sell something, my brand, or I'd like to monetize it, or I'd like to do those things. But does someone actually want what I'm looking to give? Because if I don't know what that is, then maybe I have nothing to sell, or maybe I actually have something massive, and I just don't realize that I'm sitting on a gold mine. We are busy with that conversation at the moment. Luckily, I'm talking to a bunch of lawyers, so this is a safe space. We are busy with that conversation at the moment, is what's the rights we have as sport at the University of Pretoria, and what is the value of those rights? So if I go to company X to sponsor, what do I actually have that I can give them that would be of value to them, and is it of value to them? And so we are busy with that unpacking at the moment, with various conversations to try and understand that. So I think that would be something to see, how does that come through in the conversations when you're looking at either your personal brand as a player, in this case, a Bafana player, versus, something like a wearable technology where there's a lot on the market. I think what's also important, there's a few points I made, and Prof asked me to sort of touch on maybe, some of the areas in which these IP spaces and the rights are sitting. The biggest one we got to protect is ambushing, and the potential risk of ambush in any shape or form. And then often it sits within the marketing space. I am Company X, I have a certain product. If I strategically place my product on a board at the right place in the right stadium at the right time, I have 50,000 eyes that could be gaining access to that. But there could be agreements in place that actually limits me from within certain radius. And if I take it very practically, in our world, we compete, if you happen to watch rugby in the last couple of weeks, the Varsity Cup rugby space, we as the University of Pretoria are members of a company, a non-profit company, Varsity Cup, where we then cede certain rights to them to be able to put on the show. The show is, they've got to find the sponsors, they've got to get the teams around the country, they've got to do the bookings, they have to do the activations that are required for those sponsors. And that way they give back certain value to the partners. What I can't do is, so Steers is one of the sponsors, or FNB, I can't now, within a certain radius, go and have an ABSA signboard or a Nando's. So for example, when I cede some of those rights and what is deemed to be my powers, there's certain limitations to what I can then do thereafter. And I think it's always important. The other person that is so critical in these spaces, especially when you're moving into the professional space, is this little person called an agent, right? Because there are many that float around. And if they're not on the same page, so for example, if we go back to your scenario, if the agent's not on the same page as the player that you interviewed, the risk is they could be selling something for that player. The player has other aspirations of what they believe their value is and what they'd like to achieve, and the two never align. And then you suddenly sit with issues long term. So technology developments, I think, is another key place within the IP space. Who actually owns the data of that technology? Whether it's a new watch, is it a special sensor that I've used? Is it the same sensor? There's currently, if I look at some of these wearable technologies, there's a couple of watches that are going around. They range, but they're a lot cheaper than your Garmin's. They range anything from about 1,000 Rand to 8,000 Rand, but the look and feel looks exactly the same. So now I go and say, okay, so who sits with what in that space? And how tested and tried is that? So if we were going into the wearable technology space, one of the things I think that would need to come in is the validation of the technology. Because the validation of the technology will determine whether or not someone will actually want to use it. And so if you're in that space, I think validation becomes critical. If we touch on broadcasting, we as organizations may provide certain broadcast rights. Some of those rights I may own. Some of those I may not own at all. And I think that leads to a point of where do I affiliate? And you mentioned the affiliation actually in your document is every person that's involved in sport. If I'm an athlete, so let's put my athlete hat on, or I'm a coach, I have an affiliation process. It's a very, 1800 system, all right? But I register with a club. The club registers with a provincial entity, a national entity, an international entity. And that affiliation has potential limitations on me and my rights as I go higher up. So, for example, if I'm now the same Bafana player and I am playing local football at home, I might be able to do certain things with my brand versus now sign with, and I'm not going to call a name of a team because then you're going to say I'm favoring one of the PSL teams. But if I sign with a professional team, I might cede certain of those rights and them to use some of those rights, especially in a team sport. Likewise, if I then go to Bafana Bafana, it goes up the ranks. So the same with broadcasting. I think one of the biggest risks is the OTT space. Risk in the sense that I can sit on my phone, exactly like we're doing now, and you could be broadcasting the entire match from the stadium on your phone, but those rights for broadcast have actually been given to SuperSport. So we, for example, if we want to do video footage at the Varsity Cup games, what we do is and there we just want to take for advertising purposes of the brand, which we did now at the final. It was a good space. We cleared that with Varsity Cup to say we are not broadcasting. We are taking snapshot snippets of it. We are not now going to have a Nando's board that comes into it because Steers is one of the sponsorship teams. And how do we protect that rights of it? Because they have the right to come back and say, but as a member institution, you agree to certain of those things. So I think the OTT space, whilst it is huge, if you look at the SuperSport school space, they have now millions of viewers, whereas a Varsity Cup rugby game sits in one of the top 2 rugby broadcast things on SuperSport. So you're looking at about between 85,000 average viewers per game that's watching live at that point in time, to maybe a URC game that could spike when it's a big team to say 120,000. But there could actually be more consistency. So we've got to be careful and protect those broadcast rights that we are giving away. Merchandise, massive. So if I'm going into the merchandising space, that then talks to, if you look now, for example, you'll see probably the Bafana Bafana jersey's got it doesn't have, Castle as a sponsor on what they're selling, for example, in the Adidas stores. Because when they go to the World Cup, they have to have no sponsor on, because the World Cup rights of a team competing there says you can't have your personal sponsor. So even in some of the teams, as soon as you go higher up, same with the Olympics, they protect. I'm not allowed to go and put an Olympic rings anywhere on any of our kit. The Olympic IOC has the rights to come back down and say to us, you've stepped the lines. And SASCOC, as our Olympic committee, has they have to protect it. So there's this affiliation pipeline that I think is also always important when it comes to that. Product offerings, are they really self-developed? And I think in this case, the fitness tracker, is it truly self-developed? What programs will I be offering? Is that program truly exclusive to my knowledge that I've built up? Or is it just, Pitso Mosamani has been teaching me how to do this over time, and I'm using his program and putting it into a offering? Because then the reality is Pitso might actually can come and knock on my door and say, where are those lines as well? The image rights. So I want to highlight, and this I think touches a little bit on your space, but a big interesting one that I think would be interesting for you to try and follow is what's happening in the US colleges. So in 2021, so up until 2021, it was the NCAA, the National Collegiate Amateur Association. Per implication, no student athlete was allowed to earn an income through their participation or involvement in the NCAA sporting activities. That blew up completely in 2021 and the subsequent years thereafter. So where we sit right now is they brought in what they called the NIL rules, name, image, and likeness. And that has now suddenly made student athletes multimillionaires in dollars, not rand, all right? And so what you're finding now in some of these instances, if I'm a collegiate football player, American football player, I might actually potentially be earning more or gaining more revenue as a collegiate athlete than when I sign a professional contract after my studies with the NFL and coming in at a base level income. So these are some of the knock-on effects. So that NIL game that's happening within the US college space, I think in your world, and if you want to be in sports, keep an eye there, There is some big movements that is happening there, and there it's big money. There one of their big things has been, but the college football coach has been earning $4 million a year, more than an NFL coach. And they're coaching student athletes, and the student athlete was not earning anything. Yes, they were getting full rides, so they were getting full bursaries, they were getting degrees, they were getting qualifications. You could find ways of equating that to long-term benefit, but those are some of the things. The other thing I think within the space of IP and sport is sponsorships versus partnerships versus collaborations versus donations. Where and who owns what and who can give what. There's huge data that's happening, again, in all the space. I think to touch on your point around the wearable technology, who will own that data? So if I buy that watch, is it my data still? Or may Polar use it as part of their research to do X, Y, and Z? And it's all that fine T's and C's that no one reads and clicks accept and I agree, right? But it sits in those spaces as well. And I guess it's what we then use with that data. The last thing I want to maybe share, or two things. One is your point around stakeholders. Sport is built on stakeholders. And so our stakeholder mapping is often quite confusing because we also have a little thing called egos in sport. And I always joke and say to my colleagues in Tuck Sport, we need to move from an ecosystem to an ecosystem because sport is known for its egos. And so sometimes there could be other stakeholders in that conversation and those interviews that we might not have engaged with that could have a direct impact on what you could actually achieve. And then the question then around some of these, and again, I know nothing about this space, but anti-competitive behavior in the future, could that be a thing that comes through the law space into sport? If I offer you this bursary because I can afford this bursary and you can only offer me that bursary, is apples and apples? I don't know. So I'm just planting the seed around the anti-competitive behavior. And then I want to just share one, and I happen to, one or two very brief examples that I know I need to then finish up. There's two examples that came to mind in the last, actually 2 days, ironically. The one is in the gaming space. So what they did was that Burger King, I'm going to call it by its name, Burger King, realized they'll never be able to sponsor the likes of Ronaldo and Messi. So what they did was they sponsored a third division team in a league somewhere. That third division team in a league somewhere happens to be maybe one of the teams that you can get on FIFA or one of these gaming platforms. But on those platforms, you can also select who you play with, right? So I want to play Ronaldo and Messi in my team, but I want to play with Stephen Ball United third division team whose jersey has got Burger King all over it. So now what happens is that specific team, the little article I read, had more people using that in some instances, that team to play with, than some of your big name teams, but they were selecting the likes of Ronaldo and Messi. So suddenly, Burger King had Ronaldo and Messi in their T-shirts without paying them a cent. So where do those lines in the sand eventually get drawn? Because Ronaldo and Messi would have probably ceded certain rights and image rights to the gaming guys. Then they can't say, I don't want to wear Burger King, or I do want to wear Burger King, right? So I thought that was quite a sneaky way of doing that. The other thing is the scenario around merchandise and that. And the story, and you may have heard it in that, was when Michael Jordan was approached by Nike, and Nike wanted to get into the basketball space, it was his mom who said that I want a royalty deal. You need to work it in to that for every Jordan shoe that gets sold until infinity and beyond, he needs to get something back from that. That was a new way of doing it. There was a lot of negotiations that obviously had to happen. But on Sunday, I was watching the Grand Prix, and we were trying to work out what some of these guys are earning. I was trying to tell my kids. And I said the top 10 earning sportsmen of the world. Today, Jordan, who retired, I think, in 2005, is still every year the highest earning sports person because of the royalty he gets from every pair of Jordans sold. Those are the knock-on effects of a decision that somewhere along the line, his mom saw the vision that my son has actually got value. And she realized the value wasn't actually playing. And there's a little quote I remember seeing where she said, you know, he will add more value to basketball than basketball will add to him. And now you can still see it. So I just want to share those two scenarios because I think sometimes we don't always think about what that long-term knock-on effect is with some of these type of negotiations. So I think that's just some general thoughts. I'd hopefully give some other perspectives. Hopefully it was in line with that. I'm happy if there is time, if you want any questions, happy to try and answer anything. But again, I'm no legal expert in any way. So don't ask me anything about next week's court case.
Thank you so much.
Happy.
Thank you. I'm standing back there and I'm saying to myself, I know people. Thank you so much. Does anyone have questions? Yes, you can.
Thank you. You spoke about drawing the lines between sponsorship versus partnership versus collaboration and donation. How does one begin? Where does one begin?
So I think in my mind, it's understanding what you should be giving in each of those. So in sponsorship, there's ROI that I need to measure, right? And the ROI might be a financial ROI. So if I'm giving R1 million sponsorship to this team, I might have an expectation of getting 3 to 5 million rand a year in return that can be measured. X number of boards, X number of coverage, how many eyes are on the board, all those type of measurements, and there's companies to do that. When you go to collaboration, is it two entities that are coming together with a common goal? They're not measuring ROI in the rands and cents space, but they're saying it could be maybe seen in a CSI space. So it could be seen as, how do I make an investment that is socially correct? That has a very different measurement tool, because that you could be measuring in the end user's experience, the end user's value that they've derived from it, and not a rands and cents. And then the last one, if you take about donations, well, that could be looking at things like my scorecard, my BE scorecard has a very specific outcome. I want to get points. Call it what it is. It is what it is, right? In terms of donations, I don't expect a rand value measurement back. And sometimes in the donation space, you never even know. You don't have to put up a board somewhere that says Stephen Ball Foundation gave 2 rand. It's not part of it. So I think knowing what you want out of the relationship will derive which one of those you start looking at, if that makes sense. Mm.
Thank you for the wonderful presentation. There was so much out of this.
Anybody else have questions?
Am I going to be marked?
Thank you. Judged. I enjoyed that. Thank you. But I wanted to know, just like they have in the States, with this NIL and the NCAA, the sports people there are making such an impact as students. And for me, they need to be educated to going into the real world. Are we doing that here in South Africa?
So they aren't making the money here in our world. But I can tell you, I got my list yesterday. I got my number. 283 student athletes at UP will be walking the stage in the coming 5 weeks of graduations. That's student athletes that at some stage have represented a UP Tux 1 first team in one of our 30 teams into student competition or higher, but they will be leaving the university with a qualification. In our Varsity Cup rugby side that won 3 weeks ago, that squad has got about 40% postgraduate students this year in. That for me is the impact. Because it means if you go back and we reworked our Tuck Sport vision about 5 years ago, the last 2 words that I included there was active citizenship. Because one day sport will end and I need to walk into society and be an active citizen. An active citizen in my mind is I contribute whilst I might be getting something in return. In South Africa, we often like to just moan, but we don't want to do the active citizen part. We call ourselves citizens of the country, but if I walk past rubbish, do I pick it up or don't I? It's a simple equation in my mind and back down to the simplest form. So for us, we want good people leaving. Is it an easy process? No. But that's our end goal of what we do. And hopefully in some way it is happening.
Thank you once again. I just thinking around the issue of sponsorship where as a team or an individual has been given this sponsorship. So how do you best conscientize them of those terms and conditions? If you don't reach this, we're going to pull out from, and how do you get to make sure that, take for instance, you depend on this sponsorship to move to the next level. How do you get to conscientize the team and or individuals? Yeah.
So I think you raise a really important point, and I didn't mention it, but I think there's a lot of education and knowledge sharing that needs to happen in the sports space. So if you ask where can a collective like this play a role, it's exactly in the educational side of that. Education at board level. All these federations or companies have boards. They are people that have to make decisions around, do we agree with the sponsor? Can we live with the sponsor? Do we want the sponsor? Do we sign with the sponsor? Are they educated and equipped to be able to do that? The same as governing bodies that sit in our country, most of which are elected people, right? If you serve on our National Olympic Committee, you are elected through the ranks. So it's your federation that will nominate you, and then you will caucus amongst the other federations to get myself to be vice president of SASCOC, as an example. But are those people conscientized? My English data is running out. Are they aware of the dynamics that they're dealing with? And have they been educated, and do they have the knowledge? So I think it's a massive knowledge thing. It goes back down to coaches. It goes back down to athletes. At the end of the day, the athlete has to move around on the field. So in some instances, for example, you will have scenarios where if I affiliate with this club, I have to wear their kit, but I don't have to wear their technical item, which might be the togs. So if I choose Nike, Reebok, Asics, Adidas, that's your choice. But Puma is the sundown sponsor, all right? And knowing where those lines are. What you also got to be careful is, and that's where the clubs then have to look at, is like, so now I'm privately sponsored by Adidas, but do I vocally go out and run Puma down? The risk then is that my professional contract is at risk with my club. And there's been instances. Now, we're not all Ronaldo, right? Who can sit in a press conference and a bottle of Coke gets placed in front of him and he takes it and he puts it on the floor where millions of people are watching. What statement is he making? He's making a statement against Coca-Cola, all right? The sponsor of the event. They leave him. He's Ronaldo. I'm not Ronaldo. If I do that, they'll probably fetch me at Jose Mampuro or something. But the reality is it's an education process for me. So are we providing them with the right questioning? The other risk we sit within our country is because we come from a country of need, right? That need often gets abused. And I see this in the football space, I see this in the rugby space. People get contracted on these low entry contracts starting out. They promise in the world. Some of these big teams, rugby, football, cricket, they contract large numbers of players. That person gets no match time because only 11 people are running around on the soccer field every weekend, right? That person's holding tackle bags in rugby. 2-year contract, they have minimal game time, they get released. They don't get re-signed as senior contracts because they don't have game time. Then what? So there's an ethical line for me as well. So sometimes, coming back to the university space, not to promote university, but sometimes it's better for that athlete who knows they're not going to get much game time to rather go into the university space, get game time, get good development, get a qualification, and then potentially be considered for professional contracts thereafter. But that's an education conversation. Very tricky.
Okay. Follow up to what you've been saying. When you mentioned and when an athlete cedes the rights to the sponsor, for example, I understand that it's for that particular period until it ends, the contract ends. But up to, like, what can the athlete not use during the period that he ceded the rights to the sponsor?
So it would be very dependent on what the sponsor wants. And also in some cases, you might find a sponsor will say, okay, but let's go back to the shoes example. I'm signing with Puma and then I move to Adidas. Potentially my contract I had with Puma might say that I might not say anything about that company for a period of time thereafter. A year, 2 year, whatever the case is. So it depends on some of these contracts. And that's where your agents, if you're working through agents, or your coaches are critical people in our country because they are often the people that the athletes listen to. It's the people the athletes trust. Because I always say to the colleagues and the coaches, you are often the person that sees that athlete way more than their parents, their siblings, and anyone else. Because you see them 10, 20, 30 hours a week. You have a responsibility to also help with the education. So it really depends on the type of sponsor, what that sponsor wants, and what they want to protect. Cool.
Thank you so much, Stephen. Thank you, everyone, for your questions. We are done with this segment. Stephen has to run for a meeting, but before he goes, do we want pictures? Do we want? Yes, we want. So let's do that here. No. No, we want a picture with you. So let's do that here. Sit. Yeah. Quickly. If you don't run here, you will miss out on the... You should actually stay in front to miss your hands. Very good. I love it.
The ones who know.
Yes.
Okay, let's try and huddle up. You sure just come in the front?
What does that mean?
Okay, cool. Big smiles, guys. 3, 2, 1, cheese. Say tax. Okay, one more. Last one. Okay.
Thank you.
Thank you so much.
Thank you so much.
Okay. No.
Yeah. Yes. This is the just to get to communication. Thank you. We'll chat on the evening. Thanks. Who is speaking next? Benedict.
Good morning, everyone. My name is Benedict Moyo. I'm a PhD student here and also a research assistant in the Data Science Law Lab. So I'm just going to take you through our hackathon highlights and submission overview. So this year's hackathon brought together a diverse and interdisciplinary group of students from multiple universities across Africa, representing a range of countries and academic backgrounds. So in total, we had 36 participants forming 4 teams. This reflects strong collaboration across law, technology, and policy disciplines. So the challenge actually focused on the use of AI in public administration, specifically within the intellectual property offices. So across the submissions, teams engaged a wide range of IP institutions, from national IP offices to regional bodies, and also explored practical use of cases. Some of these cases include the AI tools for improving efficiency in examinations and registration processes. We also have the data-driven system for innovation mapping and policy foresight. And then the last one, also have the solutions addressing copyright, trademarks, patents, and design administration. So submissions, they also reflected careful thinking around ethical governance, including transparency, accountability, and human oversight in AI deployment. The judges evaluated submissions based on strategic impact, feasibility and technical understanding, ethical robustness, stakeholder engagement, and overall clarity and coherence. So from this process, top teams, they were identified based on how effectively they combine practical solutions within the forward-looking policy thinking. And during the evaluation stage, judges also engaged with teams with questions that tested the assumptions behind their proposals, their feasibility of implementation in African context, the management of risks, including bias and data governance, and how their solutions aligned with existing legal and institutional frameworks. So overall, the hackathon showcased not only innovative ideas, but also the ability of students to critically engage with complex real-world policy challenges at the intersection of AI and intellectual property. So my colleague Zinzi will take us through the rules of engagement and teams demonstrations, and to also introduce our judges. Thank you.
Good morning, everyone. My name is Zinzi Shabangu, and I am a research assistant at the Data Science Law Lab. So before we proceed with the business of the day, I would like to introduce the judges. So firstly, we have Dr. Hamza Monkari. He is a postdoctoral research fellow here at the University of Pretoria. He is also working with the Data Science Law Lab across our various projects, especially the catalyzing AI's potential in Africa through intellectual property innovation. Dr. Monkari has authored a substantial body of work in both national and international law journals, and he is a significant contributor to the discussion in private law, data regulation, and related fields. Then we have Ms. Seani Rananga. She is an academic staff member in the Department of Computer Science here at the University of Pretoria, and she is a senior member of the Data Science for Social Impact, DSFSI for short. She is a specialist in the field of machine and deep learning, and her research interests include multilingual and multimodal AI, misinformation and disinformation detection, and explainable AI. And this is just a few of many more. Then we have Nicolette Begar. She's an experienced intellectual property attorney at an international IP firm, Inventor. Her career spans across various roles, having occupied roles at a big South African law firm and a boutique law firm in New Zealand. She's a former assistant registrar at CIPC and a legal advisor at SAMRO. She's passionate about imparting knowledge to the next generation, having lectured both attorneys and law students. So the hope with having judges with such diverse backgrounds and specialties is that the teams presenting today can benefit from their expertise and have nuanced perspective coming from these judges. So we are very thankful for their presence today. So the rules for today is each team will have 10 minutes. So in this 10 minutes, 3 minutes will be reserved for you to present. And then the next 3 to 4 minutes is reserved for you to respond to the pre-shared questions. And then in the remaining time, you will receive feedback from the judges. So we'll stick to this 10 minutes very strictly. So please make sure that you use it very effectively. And thank you. I wish you guys all the best.
Is the AfriIP-Tech team, are you afraid to approach the podium? Your time has started running. You can stand here.
Okay. Then with the slides.
I can't, so you can see it here, but you can tell me next slide.
Oh, okay. Thanks. How do I move from?
Yeah, you press here. Look.
Okay. Good morning, everyone. I will be presenting this pitch on behalf of my team, AfriIP-Tech. Next slide. So, firstly, what is the problem? We believe that a blind spot in trademark digital search within South Africa's SIPC exists. Although SIPC already has taken strides towards digital support with its AI-assisted visual trademarks tool, this existing functionality is limited. Trademark similarity is assessed across 3 dimensions, and the current image search only addresses the visual and semantic aspects. So, what is missing? Phonetic similarity. How marks sound to a consumer remains entirely dependent on manual examiner effort. Because examiners manually check phonetic similarity across a register of 42,000 annual filings, it contributes to the 10-month official action turnaround. Next slide. This tool, so what is our solution? Our solution is a 2-phased AI intervention. Phase 1, a phonetic trademark examiner AI. This tool automates phonetic similarity checks using machine learning trained on 11 of SA's official languages. It therefore reduces substantive examination time from months to mere minutes. Phase 2 is an IP intelligence platform. It converts unused filing data into a live dashboard that identifies innovation gaps and market trends, allowing the government to make evidence-based industrial policy decisions. Next slide. Both tools are designed to function within the IP online e-filing and examination workflows. Next slide. These tools matter because they bring linguistic justice to IP protection. They significantly speed up trademark examination process, help reduce backlog, and improve overall turnaround times. They enable us to benchmark our innovation against ARIPO member states and global peers, moving South Africa from reactive to anticipatory governance. Training our AI on 11 official languages ensures that trademarks in indigenous languages receive the same rigorous high-speed protection as English ones. It leads to higher quality trademark registrations, fewer oppositions, and stronger protection for businesses. Next slide. Feasibility. The system uses mature phonetic algorithms that can be rolled out in phases, beginning with English, Afrikaans, and Zulu. The required skills, training, and funding are well understood and achievable within a government department context. The system serves as an assistive tool with final decisions retained by SIPC examiners. The system directly targets real operational challenges and has measurable outcomes. Local linguistic expertise exists to handle language complexities. The system includes mandatory bias audits and is fully POPIA compliant to protect applicant data. Next slide. We aren't just building a faster filing system. We are the first to combine multilingual phonetic AI with a national IP intelligence platform. We are turning the SIPC from a regulatory hurdle into a world-class strategic asset for African innovation. Next slide. With good data and the right technology, people and institutions today can still solve hard problems and change the world for the better. Thank you. Yes.
Is it? Oh, they have this. They must use that one. They must use this one. Okay. Please. You okay?
Okay. Thank you so much, AfriIP-Tech, for a great presentation. I have one question for you. I think I was more interested on the phonetic AI because it incorporates the multilingual part. That's part of the work that I actively do on a daily basis. So in terms of two trademarks, how are you going to check the similarity of the phonetics, checking how will it meet the legal standards, especially across different South African languages? And in addition, if an applicant disagrees with an AI-generated output, how are you going to actually, because your system doesn't mention what happens if, as an applicant, what happens if AI gives me information and I'm not agreeing with that? And also, if you were to deploy a system, what will be required to implement and sustain this?
Thank you for your question. The first question on how will our system be able to determine the two trademarks which are phonetically similar. So the proposed system will use phonetic modeling and machine learning trained on past trademark decisions. And then including, you see, since on the languages part, we will also use the language experts to differentiate all those trademarks based on the phonetics, including any language that might be used in those assessments. It will assess similarities in line with the likelihood of confusion standard. The system will also provide evidence based on recommendations. And all in all, if there's like two different trademarks which are similar or there's a problem with them, what would happen is that the final decision will always lie with the examiner and the CIPC. So even though it will go through the AI systems and then all those things, and then there should be a problem or any similarities, the last person who would issue out a finality based on that trademarks would be the examiner. So now on your second question, to say that if there's anyone who disagrees with the decision Remember, the CIPC is an organ of state, so the PAJA would definitely be applicable, whereby one would have to be explained, or one would have to be given a reason as to why was the trademark rejected in that regard. So especially when you look at Section 3 of PAJA, which talks about procedurally fair administrative action affecting any person. So that kind of a decision, if that person is not happy with that decision to say maybe their trademark have been rejected, then that section would apply. Also Section 5 of the PAJA, reasons for the administration active action, and also Section 6, judicial review of administrative action. Remember, if you come to a point where one is not in agreement with everything, and also they can judicially review that decision to say, no, the CIPC is wrong in rejecting my trademark in this at this stage, then you do the judiciary review. I'm not sure if I've answered everything. Yeah, thank you so much.
Do you have general feedback on their submission or?
So the general feedback from your submission, AfriIP, there is a strength in the phonetic similarity part from the legal perspective. I would not expect you to understand more on what happens with the machine learning algorithms part, but I think a good collaboration with the machine learning guys can actually now help strengthen this point. Also, the other strength was the transparency part, where now if your system rejects an application, rejected applications can actually now be used. You mentioned that they can be used they will be available for the users so that now they can see what was missing. So that was the strength part, because there's a lot of work that is being submitted to CIPC, gets rejected, and we don't get to see what happens. So if now we have that part from the system of rejected applications, that was a good strength from my side. Also, with that, the other thing on the AI side, you can incorporate something called explainability of AI, explainable AI, that can also from the machine model side assist you with that. The multilingual part, of course, for me, it's good because we are living in a world where we want AI to also understand our languages, because the users of the systems don't only solely rely on English understanding. The last part, you didn't mention it in specific words per se, but one thing that will strengthen your system is the use of retrieval augmented generation, which is the RAG, because that helps you now to incorporate all your laws, trademarks on the system, so that if a user has been told something, instead of first going to the registrar or the examiner, the system now can retrieve some knowledge, and then from then, if they are not happy, then the second part can be now going to the person, but not just if you're happy with the first feedback, then it's fine. Yeah, thank you.
Thank you so much, Seani. Give a round of applause to them. So you kept to time, which I endorse. So I'll give you 0.00005 marks for keeping to time. MASA IP is next, right? Yes, please, let's do it. Be encouraging people.
Good morning, everyone. I will be presenting on behalf of Malawi, South Africa, otherwise known as MASA IP Innovation. Next slide, please. What are the problems? So firstly, Malawi and South Africa face technological challenges in processing IP data to be efficiently accessed by the global community in any space requiring the use of IP laws. Secondly, there's the increased risk of AI-generated content being registered under the false impression that the work was created with human innovation. And thirdly, there's the lengthy process of analyzing submissions, including authorship, patterns of AI-generated content, and filing history. Next slide, please. What is our proposed solution? We have proposed a targeted AI tool that will combat under-resourcefulness, application processing times, curb the rise of fraudulent applications, and ensure stricter compliance with regulatory provisions. This will be performed by an AI tool that alleviates administrative burdens, lengthy registration processing, and assessment of patents. The tool will identify AI-generated submissions, fraudulent creations, as well as duplicate patent and copyright submissions. Next slide, please. Why does this matter in the African context? From Malawi to South Africa, Africa is filled with young, bright minds who are eager to bring Africa to the forefront of innovation. However, issues such as administration, fraud, and the growing use of AI-generated content is stifling human innovation on our continent. By clearing backlogs and protecting human creators, MASA IP provides a system that promotes African innovation while ensuring that the IP system works in a speedy, fair, and legally sound manner. MASA IP proposes one AI tool that will provide 3 solutions. Next slide, please. Firstly, clearing the paperwork. We seek to tackle administrative exhaustion in patent registrations through a digital formality compliance checker. This tool acts as an automated checklist that verifies if applications meet national laws. By handling routine paperwork, it reduces procedural review time by 60 to 70%. Next slide, please. Guarding the registry's integrity. As the use of AI increases, it becomes more difficult to ensure that copyright and patent submissions are purely creativity and innovation and not AI-generated. Our system spots fraudulent or duplicate submissions by analyzing patterns and looks for fingerprints of AI usage. The tool will provide an evidence package of suspicious content, which will reduce human workload by 40 to 50%. Next slide, please. Thirdly, the human heart of the system. MASA IP seeks to maintain fairness by keeping a human in the loop. While the AI system may spot any irregularities, ultimately the human examiner makes the final decision regarding the processing of the given content. Furthermore, the system will ensure that each creator is judged solely on the merit of their work by being programmed to disregard personal data such as gender, location, etc. Next slide, please. How feasible is our proposal? So South African registration occurs through the CIPC and Malawian registration occurs through the AfriIP-Tech. Thus, there's already established platform for registration. We offer a plug-and-go system in the form of an AI tool that can be interconnected to the already existing platforms, which allows for a shorter changeover period and minimal teething issues. By using MASA IP-appointed technicians, analysis paralysis can be avoided and thus allow for better focus on the most critical and high-risk areas of the program while imposing regular updates to ensure the system remains legally compliant. Next slide, please. What makes our idea distinctive? Well, firstly, most AI systems work on probabilities and essentially make a best guess. However, the AI tool proposed by us is hard-coded with the specific laws of Malawi and South Africa. In this way, the system will validate content based on the relevant legislation rather than guessing. Secondly, our system goes beyond flagging and rejecting content, but instead provides an evidence package that shows why a particular submission was flagged and which part of the content was flagged. This will reduce any heavy investigative work for the human examiners. And thirdly, our system is constructed for absolute fairness. While many systems try to avoid bias, our system is blinded to personal data. The system is barred from seeing an applicant's name, gender, location, etc. This ensures that innovation is judged solely on merit. Thank you. My colleagues will handle questions.
Thank you. That was well presented. My question is, how will the system determine whether a patent or copyright submission is fraudulent or AI generated in a legally defensive way?
Good morning, judges. Good morning, everyone. Our colleague in Malawi, Omega Misomali, will take the first question. Thank you, judges.
All right, thank you very much. So the question that you asked is how we're going to make sure that it is working, but it is still legally defensible. So firstly, we're going to it's going to use a three-stage method for it to identify or flag the fraudulent or AI-generated copyright or patent. But to make sure that it is defensible, it is going to ensure that the reject or to accept an application is made by a human expert or the human factor. When I say that there are going to be three statements, I mean that first there's going to be feature extraction, whereby the patent or the copyright is going to be looked at, and the AI is going to take if there is a given a pattern to how an AI makes, like how the other AI are going to make the patent or the copyright the difference. And because of that, if there is some other applications that look like that, or other related applications that also look like that. And then after that, there is going to be an anomaly scoring, which is basically checking how deep or how close to that wrong submission is. So wrong submission, I mean that it is fraudulent or it is made by AI. And then thirdly, it is going to gather up what it is better than the feature extraction and then the anomaly scoring as evidence. It is not going to provide that to the expert to view it and make the kind of decision. So this is what we can call that it's going to make an experiment or AI, it is not just going to flag the pattern or the copyright. It is going to flag it and bring up the reasons why. So it is especially defensible by law because I believe that the issue was it is not possible for a person to see AI or to question AI, but rather because it is the person that is going to make the kind of decision, so it is defensible by law.
I'm not sure if she was audible, judges, but I think that's the end of our first answer.
Thank you. I think it'll just be that one question, but some feedback. And I actually found this for me across all the submissions, not only for MASA, was did you really delve into the reasoning behind why this is important to check for fraudulent or AI-generated patents or copyright submissions? Because for one, you talk about formalities, but specifically for patents, there's the formalities aspect and then there's the substantive aspect. And I don't feel that that was addressed in this particular submission. And why do you think there are fraudulent submissions happening? Does it come from somewhere? Was there research done into the background of, is it so many that you would think it's going to reduce the workload by 40 to 50%? I don't see the connection between this kind of checking and the fact that there's going to be a reduction in the workload. Because in my experience, I don't see that there is such a high level of fraudulent submissions or patent applications or copyright. Look, copyright is not registered. It's not registered by the CIPC. There is for cinematograph films, but copyright is not registered. And I don't believe that it is in Malawi either. So the basis of fraudulent copyright submissions, I'm not getting. Also, AI-generated patent applications. That is something that is now coming to the fore. There has already been a patent somewhere in the world that has been registered that was invented by AI. The invention was by AI. So the way the world is moving, looking at whether it is an AI-generated patent application, I'm not so sure that that is something that will assist patent offices. So that was my feedback. But I did like the fact that it was something where you can make an effort in approving efficiencies at an IP office.
Thank you. Thank you. Who's next? Munchinos. What kind of technological challenges is
this one?
You need to move your podium to this.
Okay, but we don't have this kind of plan.
Just start talking first.
Okay. All right, it's fine if it's not there. Okay. Good morning, everyone. Good morning, fellow classmates and scholars. But most importantly, good morning to the judges. You are looking like typical local parentas. I do hope, I do hope that you will be that way. Dumelang kamuka, molibwanji, bonjour, annyeonghaseyo, sanbonani, goeiemorgen. So I hope I did not leave anyone behind. I hope we are all okay, and I hope I've managed to greet you all. All right, fantastic. Now I wanted to use my laptop, but it's fine. We made an alternative plan. It's okay. Right. Okay. Yes. Okay. Problems that are faced. Now, some of the problems that are there are the challenges of untapped potential of large IP data for innovation, a lack of resources, therefore processing times are longer for applications. There are updated systems. I mean, if you go to the CIPC, you will see that they have technology. They have machines. Some of the machines are, I think this height. So it's not that big of a problem for those who are a bit taller. But those who might not be so tall, it might be a problem to make use of those machines. Another problem is language barriers and comprehension. Now, if you visit the CIPC, for instance, you will see that there are 4 machines in the office there, and their offices are based there by close to Steve Biko Street, but they used to be in Suncadia at the mall. Now they have moved to the other mall, okay? So if you go there, you'll see that they have these 4 machines all around. Now, those machines are brilliant. They are updated, they are touchscreen, they are fancy, they're very nice. The only problem is there's a lack of manpower. So let's say, for instance, there are 6 people here, and then there are 6 people waiting in the queue. Then you have others by the machines. So there's only 4 machines, all right? Now, whilst one person gets assisted by these machines, the others are waiting. You can use the machines by yourself, but most cases, there's so many questions and things that are not easy to comprehend that it becomes difficult, that you do need a human element, somebody that works at the CIPC to actually help you run through whatever it is that you may be doing, whether applying for your patent or registering your company. Now, solutions. The solutions that I'll mention, I'll firstly start off with RAG. All right. Okay, next. Yeah, this is fine. I'll start off with RAG. Now, RAG is highly essential in helping curb the problems. And how will it help curb the problems, this RAG? Now, I'll explain how the RAG system works. So what happens is you as a user will put up a user question. Thereafter, RAG will take that question and look at the internal and the external database. So the internal database would be things like your company documents, the PDFs, and your data sets. And the external would be the public database. So now RAG will then take all this information, process it in this retrieval layer, and then turn that information into context or information that is easy to understand and to comprehend. Now, after making the information easy to comprehend and to understand, RAG will then give you a final answer or response. Now, the system uses both user query and system instructions to make context into a single updated and upgraded prompt. Therefore, RAG inputs are unique in that regard, as they are better and can be used for many applications. Therefore, production assistance will be better. Internal search systems will be better as well. All right. So I'm left with 1 minute. RAG will also be used with trademark similarity classification engine and automated patent formality checkers. And with the RAG, we can empower all these systems that could be used. I think my time is up, so I'd like to say Kyaleboha, Nyabonga. Thank you very much. I hope I did not bore you too much. All right. Questions? Okay, questions from the judges?
Thank you, Munchinos, for the presentation. I think you intelligently answered some of my questions through your presentation. I don't know how you were doing that. But probably can you give further emphasis because on your document, not from your presentation because you didn't have time, mentioned about AI-generated recommendations. How will you now use the RAG to actually ensure that those AI generations can be detected accurately, and it also gives a legal, reliable feedback? And also, how are you going to handle some of the errors? And then secondly, you mentioned, you thoroughly took us through the offices of CIPC. I felt like I was in the CIPC office sitting. So how will your system reduce the processing time and the backlog compared to the current existing systems.
Right. Thank you for those questions. The answers that we came up with for those questions are that with RAG, will ensure that we prioritized groundness. So basically stating that a claim will be traceable. It will be traceable back to its source document. And then there will also be a source verification. So the system would implement a citation first. And then we also looked at vector database integrity, that the RAG will rely on the quality of the data provided. And then the error handling would use uncertainty thresholds. So if the model's score for retrieval match is below a certain score line, then it would reject that application, basically. I think the other question you asked is how will this RAG help with the slowness or what's happening now at CIPC? I think RAG would be much faster. It would be cheaper. And we would not have people queuing up because it would simplify the information for people to better comprehend. And regardless of your level of education, regardless of your background, it would also incorporate all the different languages, but also keeping it very simple for the layperson as well. So I think that's how it would be beneficial.
Thank you so much. The feedback from my side, the stakeholder plan, I went through your stakeholder plan from your submission. I would like to comment that it was really well executed, and also the faces on how for a moment I felt like this is going to be implemented really. The faces were awesome. I was really convinced. If I was, that was actually good. Possibly the implementation, I think the approach the AfriIP brought in, because now you want to introduce the multilingual part, I think phonetics will be good and all other embeddings that are there, because in terms of your lingo as the law, the one part the phonetics will help you is that it will now compare the similarity of trademarks against each other. Possibly somebody pronounced something differently. So then now it can check all those similarities, and when it is, bring back the query. And then I think lastly, not just relying heavily on the RAG. I know you extensively showed us how your RAG will be, but that can be the first point of output. Then the second one can be, if you're not happy with this output, then now you can now have a human in the loop who can now, you can say, this is what I've seen, and then I'm not happy with 1, 2, 3, and then now how do we go? As I've said, so that also then now just reduces the backlog and all that. Thank you.
Last but not least, Techwise, I don't have your slides. You emailed it after the second coming because I don't have it, but I will check it now while you are greeting
in every language. Good morning, everyone. Yeah. Thank you. How are you? Have you found it yet? Okay, so I'm Bontle Chokwe. I'm one of the members for Techwise. So our AI, okay, the problem that we saw with the CIPC, next document, please. The problem that we saw with the CIPC is that it currently operates in 3 disjointed systems, being e-services, IP Online, and BizPortal. And with that disjointed services, we are losing data, as well as we're losing companies that can actually register for trademarks because they don't know. So in doing that, we are also found that these AI systems that are needed for the disjointed systems to actually connect, because currently the classification of trademarks is done for, when you do trademark, you have to actually specifically select which class you wanna you want that trademark to be in. So we decided that in order for the disjointed CIPC services to join up, we have a solution. And just so I just say, it also causes a high administration burden, which causes manual processing, delays, legal disputes, and name conflicts at the end, the way the systems are currently. Next slide, please. Okay. Yeah, that slide, the solution slide. So currently we have 3 solutions that we propose in terms of the disjointed systems to actually work together in the end and reduce high administration burden. Go to the next slide, please. The first solution is the CIPC classification system. Our tech team actually did do that part in terms of how the classification system actually works. You give the actual trade the CIPC person, the company has, and with that trade, gives you the classification that it thinks that you should be in and the reasons for it. And this will help both the company as well as the administration person to know which classification they should be in, because there is a system within the CIPC itself where it says you can request the CIPC to give you a classification and you pay a certain amount of money for it. Next slide, please. The next solution is the AI-powered pre-screening tool. This one, after you do the classification, you need to do the AI-powered pre-screening tool in order to see if there's any conflicting marks on the trademark system. So this system will tell you if there's any conflicting marks and give you an assessment in terms of conflicting. It also has a way of assessing if it's low risk or not, and it'll give you a platform in that regard. If you see from the one in the back, that's the one that the end user will use, being the company, and the one in front is the one the administrator will use. We could demonstrate it, but there's no time. The tech team did do it in that regard. Next slide, please. Then there's the machine learning tool and AI chatbot. In order to actually get information that you can get from these 2 tools. You get information on the company side as well as the trademark side in terms of which information is needed. And you actually get it quicker with the AI chatbot in terms of the exact information that you need in that regard. Thank you. Next slide. And we think that it matters because SMMEs drive the economy, and therefore the link portions will ensure that companies actually register trademarks. As I said, currently the CIPC in the 2024-2025 stats that they gave us is that there are 31,000 trademarks that were registered, but on the other hand, there are 488,000 companies registered. So that's an issue in terms of the lineage in that regard. As well as the AI tools itself, because they both for the end user and the administrator, it will cut down the administration time. Currently, the administration is about 9 to 12 months, sometimes even more. And because of the way it's done, it gives you a report instantly. Therefore, the administrator could just read it up and see if there's anything missing and actually go back to and have the final result in that regard, as well as determining class as we spoke about. Then we go to the feasibility part, is that our proposal uses existing structures and system. It just integrates Next slide. Thank you. Sorry. It just integrates into the system itself. There will be a button on the e-services and biz portal which says when you register a company, register through the CIPC, register an IP and a trademark. And then when you click that button, it actually goes to the other pattern. So the linking is not actually a new system altogether. It's an API linking system that will ensure that there's a window open for you to get information from the other side, and therefore also keeps the integrity of the systems altogether. It also is, it promotes the pilot product. The way we did the steps on how to do it in terms of feasibility is that these pilot product programs, human oversight, as well as workshops and training for the stakeholders that are in line. Next slide, please. Originality is that there's a potential for company registration landscape in IP where we're using company data as well as IP data, meaning the GDP of the country can be lost in that regard because we now know how many foreign companies are actually registering IP, not only in terms of patent, but actually there is innovation in trademark in itself. Furthermore, there is an AI risking score, real-time policy data insight, and cross-system integration in that regard as well. At the end, there's a data intelligence hub. Next slide, please. And no, I think that's it on my side. Yes, go back to the other side.
30 seconds. No, I'm trying to help you to...
No, let's go back to the other side. I'm done. Yes, the originality. Yes. Yes, then I'm done. So the other slides are for the questions asked. Yes. yes, thank you.
All right, thank you. I would like to congratulate you for the presentation. So I will adopt a different approach. I will give my feedback, maybe, and the question comes next. I read all the policy proposals with a lot of interest, and this is due to the significance and relevance of the topic under consideration, AI, and how it shapes the continental economy in providing more public services and equally shaping the law. But my remarks is that most of the teams didn't precise the particular AI tool they were referring to. They were more of descriptive. So I don't know if you have the same, you guys were more descriptive, like you use descriptive phase to refer to a category of AI power technology. I'm not into high-tech issues, but sometimes when you are making a policy proposal, you have to be specific on the tool in question. Because I believe if we have various AI tools on phonetic issues, I believe all of them have their efficiency levels. So you must actually be specific on that. Secondly, some did not identify limitations and risks related issues. You know, when you are writing a policy proposal, the goal is to actually seduce decision makers as well as stakeholders to actually take out an action or amend existing ones as far as problem solving is concerned. So you cannot just make a policy proposal and just explain only the merits of what you are proposing. You must equally identify the risks, because that is what will enable the decision makers to actually calculate the cost effectiveness of what you are proposing. So that is something that was absent in most of your proposals. And that leads me to my question, how will the system determine and validate risk levels? Okay.
Thank you so much. There's someone who's going to present online, one of our tech team, Tiam. Yes, TS, yes, that one.
fixed rules and a scoring system. The rules check for things like trademark conflicts, invalid company details, or possible fraud patterns. Each issue has a set severity. For example, that makes the system consistent, easy to justify from a legal perspective.
Yes.
Yeah, that's it.
It's fine.
Oh, that's the only question. Okay.
Techwise a round of applause. Okay, thank you so much to all the 4 teams for your presentation. After the judges announce the results, I will tell you what next steps are. But needless to say that you have to keep the feedback and the questions that you got and the reactions you got from the judges close to heart, because it will be very important for the next phase of your final output. Okay, so the work is not done, but you can see that you're making progress. You should be proud of yourselves. I hope you are. Yes. Don't be worried. Be proud. This is how you can see how policy making is. You have to convince people. You have to carry people along. You have to think about what you are putting on the table as a policy solution. But well done, everyone. I think your solutions were very interesting. So while the judges are deliberating and adding up their scores and preparing to announce the results, we will hear from Refiloe giving her presentation on the IP simulation so that you can hear more about it, and then we will be wrapping up. Give her a round of applause. Here's the mic. Let me load your.
Thank you. Good morning to our module leader, Prof, and our esteemed judges, our fellow classmates, as well as all the guests. I will be presenting the IP simulation. It is a 3-part. I did the memorandum first and then the video recording. And now it's time for the presentation. Next slide, please. As part of the presentation, the presentation will give us the introduction of the IP simulation and the overview of the client scenarios, which are 2 client scenarios. And we'll focus on the key IP issues. We'll address the strategic recommendation, and it will also speak to both IP issues and the recommendation that we have given, and we'll have our conclusion. Next slide, please. So the objective of the simulation is to ensure that as students, we are able to identify IP rights and how they are protected, and ultimately venture into commercialization of such IP rights. So the overview of the client scenarios, as mentioned, we have 2 client scenarios that were developed based on real-life sports examples. These include, the first scenario will be about a professional South African athlete who is building a personal commercial brand. And then the next one will speak to a sports tech startup organization who will develop wearable performance tracking technologies that are worn by athletes, such as your sports watches. You will see most of them have them. So each scenario will involve multiple overlapping IP rights and address real-life legal changes that are encountered by IP advisors in the sports-related field. Stephen mentioned earlier that in everything that we do, it attracts IP rights. So where there are IP rights, there are also challenges. So we will address them as well as we move along within the presentation. The first scenario will speak to a client who is a South African professional footballer, primarily affiliated with Orlando Pirates, and as well as Bafana Bafana, the South African football team. So he's a popular, we all know him. His name is Relebohile, and he goes by the nickname President Yamatuke. So basically, the activities that Relebohile wants to engage in, he wants to strategically protect and commercialize his IP brand, his personal brand, as the core business asset within the sports and wellness market. This includes the logo, and the distinctive logo as trademark, enabling exclusive use and preventing unauthorized third-party exploitation. Next, he would also like to develop and sell branded apparel, including items such as shirts and all other items that are related to his brand. And in addition, the clients would like to monetize the training performance and lifestyle contents. I'm sure most of you are aware of content creators, a lot of them on social media, and they're all trying to monetize those assets. And then finally, he would like to co-develop a subscription-based fitness training mobile application, like the ones that we have on our phone. So as I've mentioned, that each and every IP right, how do I put this? Everything that you do, that the sports person does, attracts IP right. So the identified IP rights within Relebohile's environment would first look at the trademark aspect. So the first IP right will look at the trademark, which includes Relebohile's name, any logo associated with his products, and any slogans that he's associated with. And then the second IP right will be copyright, which includes all videos, content created by Rele or where he is featured, and all digital media and training material associated with Relebohile. Then we'll look at the image and personality right. This will cover any commercial use of Relebohile's likeness as well as his reputation. And lastly, it will also attract trade secrets, which will relate to the exclusive training methods and routine that are used. What legal and commercial challenge will this pose? You may want to ask yourself. So the client faces the unauthorized use of the athletic's name, image, nickname, and further, there are complexities arising in respect of the fitness application where ownership of app-related content, software code, training program, and data may be unclear. So we need to have contracts that speaks to who owns what and up to which extent. So the strategic recommendation will be to register the client's name as a logo with the CIPC. And in addition to registering that, to have written contracts between the parties. And lastly, image rights clauses to be added in endorsements and sponsorship contracts, which will regulate how the client's identity may be used in commercial partnership. Then the second scenario will focus on slide 8. The second scenario will focus on the client being a sports tech startup developing wearable performance tracking technologies for athletes. So if you look at a wearable device, this may not be a wearable device, but if it's a sports watch, it will have the design where you can have a claim for its design. And in addition to the design, it will have the data that is output by the device. So all these rights need to be registered accordingly. So the IP issues you will also come across is uncertainty around the patent eligibility of software-related invention, and as well as the client will face ongoing risk of reverse engineering in a sense that everyone will try to mimic or imitate the patent. So the strategic recommendation will be the filing of patents application at an early stage to secure priority dates while allowing continued refinement of such invention. In closing, we see that intellectual property plays a critical role in enabling innovations, sustainability, and commercial growth within sports. So through strategic IP identification as well as management, sports stakeholders can transform participation into ownership, aligning fully with the World IP Day 2026 theme, which is Ready, Set, and Innovate. Thank you.
Questions?
Rita, are you able to unmute?
Yes, I can.
Okay.
Good morning, everyone. Can you hear me?
Yes.
Oh, okay. Apologies, I can't turn on my camera at the moment, but I want to say congrats to the students who just presented on IP and sports, especially because of how the conversations are going for this year's World IP Day. I think I better understand her presentation after watching. I mean, I did watch the simulation and also listening to her presentation. What I would have expected from her would be, from the first case scenario, which was on image rights, I wanted her to have explained how image rights would affect athletes, especially athletes that are assigned to a club, the complications with contracts, negotiation where the club wants to have an upper hand in negotiating how the athlete's image will be used and whether the athletes themselves see that they are a commercial asset that can be monetized. So that should have been emphasized. And also the fact that with image rights, especially in sports, the jurisdiction, what are your territorial provisions for image right protections, whether as an athlete or a creative or basically an individual that wants to commercialize what they do within the niche industry. So that's just the gap I see. In relation to the case on wearable patent gadgets, you made emphasis on priority registration, but none as to the benefits of patenting such wearable gadgets within the sports sector. We have a lot of those products out there, but what makes this particular one new? And also because, I know there was a presentation on AI, but I think you should have made emphasis on how the requirements for patenting wearable gadgets that athletes will use, the communications with the terms of use, and the recent conversation as to whether use of AI to train models with existing data that will be fed into that particular app, and then the complications that come with end users agreement and stuff like that. But so far, that's it. I guess my question to her would be, from the two-case scenario now, if you were to make a proposal for a policy that would benefit the sports industry, what would be your recommendation as to how to address commercialization of image rights for athletes in South Africa, and should the requirement for patenting sports-related software be updated, especially, following the Davos case and the rest of them? So that's my question for you. Thank you.
Thank you, Rita. You can maybe stand here and face this.
Thank you so much. Can you please repeat the question? That was a fully loaded one.
She wants you to repeat the question. If so, she can. Your question. She wants you to repeat it.
Oh, okay. Let's see. So my question was with regards to policy making, because I did hear Professor mention about drafting IP policy. So what would your policy recommendation be for the sports sector in relation to commercialization of image rights for athletes, especially upcoming athletes? And also, would you advise that the patent requirements for patenting sports-related innovations to be updated in relation to the present AI conversation, and also following the Davos judgments and argument that have been going on? I don't know if you heard the question now.
I heard it. So you must have heard it. Answer the one you can, especially about the policy.
Okay. Thank you for that. In terms of policy recommendation, in terms of... Oh, all right. Can you hear me now?
Yes.
All right. Thank you for that question. In terms of policy recommendation when it comes to commercialization, I would advise that the clients that would like to commercialize their merchandise, for example, if you have a sports watch that you would like to have commercial monetize or make money out of, you need to have specification. You need to be specific on what it is and what the target market is, and where you are where it starts and where it ends. That is what I would say. I don't know if I've answered.
Yes, you answered the one on the patent question, but there was nothing else to the image rights question that I had asked.
The image rights one was in relation to what advice?
Yes.
Was it the one yeah, I'm listening.
Yeah, because I stated that image right protections, depending on what your jurisdiction, South Africa provision is in relation to protection of image rights. Not many African countries has express provision for image rights, and looking at it from the contractual relationship of an athlete and the club and any other third party sponsorship they might get, how would you ensure that the policy makes provisions that protects the athletes' interest over the club and the sponsors that would want to commercialize that athlete's NIL?
Thank you about that. Bearing in mind that most countries don't have such do not have such legislation in place, I would assume the policy should be the one to cover the best interest of the athlete. So I would recommend that we extensive research be conducted in terms of the interests of the athletes, and then in the policies state what should be focused on in terms of the policy itself. Thank you.
Your dissertation topic.
Okay, thank you very much. Thank you very much.
Thank you. Thank you so much, Rita. We just jumped into the presentation, but I wanted to say thank you and to just put in context your contribution to this segment of our program. So Rita is an IP lawyer, but more than an IP lawyer, a sports law person. She's also into IP and sports law arbitration generally. So she's an IP lawyer. She's an IP consultant. She runs a series called IP Series, which has won the World Intellectual Property Report Award. I will put her bio on ClickUp when I'm also putting up the ones for the judges. But Rita, thank you so much. So Rita read your all your submissions, watched your simulation as well, and gave points, basically graded it because she's also an IP lecturer. So Rita, maybe you will tell me, not Refiloe, but me, you will tell me if the grades that you've awarded to Refiloe's submissions, whether it's changed upwards. Hopefully it doesn't change downwards. But you will let me know. But we want to appreciate you and say thank you so much for taking the time and giving us the benefit of your time and expertise with respect to this Refiloe's submission. Thank you so very much. A round of applause for her. Sorry, you were saying?
Do I tell you now or I tell you in private?
Tell me in private. Okay, thank you. Bye. And with that, presentations are done, submissions are done. I'm going to hand back to the judges, to Seani in particular, to announce the results. Drum roll. You might want to take the floor.
Yeah, it's fine. Okay. Good afternoon, everyone. Congratulations on all your presentations. I have to do the hard part. As much as all of you guys did exceedingly well in presenting today, But in every hackathon or in every competition, unfortunately, there has to be a winner. If it was according to me, I would have said all of you sitting here today are all winners. But unfortunately, Prof Okorie.
Not this crowd, but yeah. So go for it.
That's the unfortunate part. We need to select the winner. What really amused me when we were calculating the scores is because coming up with the winner was nothing that we had to battle with my colleagues, because the winner just stood out naturally, because the marks really just stood out from everyone. So the marks spoke for themselves. Also with the second runner-up, the marks really stood up for themselves. We all we didn't even have to debate on who goes first. We all somehow just agreed from the scores before the presentation and also your presentation scores. So that really makes me happy and also gives you the assurance that there was nothing biased here. It was just all according to our knowledge and expertise. That really made us stood out. And also number 3, number 4, that's where now we had to battle to see who goes number 3, number 4. Everybody passed. At least everybody passed. But there has to be somebody who stood out. And
Suspense is killing
me. Who is the winner, guys?
Me.
Take a guess.
Him.
Who's Tabo?
MASA.
MASA.
Really?
Who's the winner? Guys, you know probably you did very bad and you know somebody did well. Who do you think is the winner?
Tell us.
Should I tell you?
Yes.
Okay. The presentations were scored out of 10 and the submissions were scored out of 25. So overall, everything is scored now out of 35. So the first winner is Munchinos. Munchinos got a score of 26.66 over 35, which gives them 76.17%. The runner-up is, this one surprised us. Let me just give background context. All judges, the 3 of us from their presentation, we judged them relatively low because we were not convinced. But when they came and gave the presentation and how they answered questions, everybody scored them a distinction. So hence the essence of being here today. You now sell yourself because you could not sell yourself from the document. And that happens to be AfriIP. AfriIP has 24.16% over 35, which gives you 69.02%. You were the least scored from the presentation, from the documentation, but now became one of the highest scored because of today's work. So congratulations. The third and the fourth is just a digit, really difference. And the third is MASA. With 20 over 35, which makes them have 57.14%. And the fourth is Techwise with 19.83 over 35, which gives them a percentage of 56.65%. thank you so much for all the hard work you've put into this. It was lovely reading all your work, and I would love to see one of this work being implemented in the real use case. And if you need some technical advice from the AI side, you can always reach out. Thank you.
Okay, last minute talk. Thank you so much to our judges. Well done to all the teams. Give yourself a round of applause. Quickly, we shall present. This year I said I'm going to be nice, do certificates, all the things. I'm so proud of myself. For the winners, Munchinos. Shepherd, please come. Certificates. Sorry? Where does now in post-event interview, where does the name Munchinos come from?
So I registered when I was in high school. I registered a business with CIPC actually. So we wanted to do a coffee shop actually, and then we kept the name. And then I was like, let me actually use this name for something. Yeah. Thank you.
Let me do like influencers.
Thank you so much.
Thank you so much. Are you going to cry and say? Okay.
Thank you so much.
That's yes. So quick. So thank you everyone, and we are going to then have everyone, all the teams, do more work on your submission. So what we want to do is to refine all the submissions into a formal policy brief. So you will receive guidance on that, on how to work through that. Dr. Hamza and I will assist you so that you can put it in a form that we can actually publish it, and then we will be able to actually directly send it to CIPC, to AfriIP, to various IP offices, for them to see how we are thinking about their operations and how we think they can improve. And then the aim is to publish before the end of 2026. So it will be each of the submissions will be properly cited, openly accessible, and actively promoted policy briefs to national IP offices and regional bodies, including AfriIP, like I've said. So we are going to really put this in front of the people who are making decisions. So you see the value of the feedback that you got from the judges and the questions that you were asked. So that should also help you build your policy brief. And it's very important to deal with the limitations and the risks. Risks and limitations are not things you hide under the table and think that you are the only one that noticed the risk and other people will not notice. Once you notice it, just assume that other people will also notice it as well. So what you then do is, how do you address it? In and of itself, risk is not a bad thing. It's just something to work towards. So you categorize your risk to say, is this a minimal risk? Is this high risk? Is this, what kind of, which level are we operating at in terms of this risk? Obviously, the more things affect human beings directly, the more you have to really try as much as possible to eliminate that risk. And that's one of the things with AI, where people don't think about the people that will use the product and just think about all the things that the products can do. So it's very important that you then, across the teams, to work on your limitations and risks, see them as live and deal with them. We have a great collaboration with Data Science for Social Impact. That's another research group in the university that is in the Department of Computer Science. Seani here is a senior member of that lab. Both of us are also fellows of the African Institute for Data Science and AI, which is a new institute in the university. So there's a ton of AI and computational, anything you want, expertise in those two groups. So you're going to leverage on that, on those expertise to think about the AI aspect of your solution to make sure that it is working. You heard the feedback about actually defining your AI tools, right? So it's not just enough to say, we are coming up with a RAG solution that will do X, Y, Z. You have to be able to distinguish how your RAG is better or more efficient or to be preferred more than the other ones, because the policymakers that will adopt these things are going to be making hard choices, right? They need to be able to say, okay, this is the reason why we're going for Techwise's solution, or the reason why we are going for this particular team solution, right? But all the solutions are great. There might be some that time-wise they have to now say, okay, based on the time we are working with, this is the one we can quickly implement, get quick results, and then we can scale up to something else. And then you heard what Nikki said about being particular about your problematization. So it's not enough to just say, oh, this is a problem, and then you rush to solution. You need to be able to show that you really, really understand the problem and that it's an actual problem, so that when the results come, you will see, the result. There's an African, it's not African, it's Igbo proverb. It's from my tribe. We say that if you don't know where the rain started to beat you, you won't know where it stopped. So you need to know the problem so that when you solve it, we can see, oh, this is the problem, this is the solution. But if you're vague about the problem, when you say you've solved it, it will look like magic and we will not be able to understand it. So that's where we're taking these solutions to a policy brief. So let's keep on hand to work on them and take them further. The other thing is that there are various policy workshops and fora that is happening in the course of the year. Some organized by us, some organized by organizations that I work with. So some of these solutions, as they make sense for different gatherings, we will take them there. So hone your presentation skills, your ability to take the time and understand the questions that you are asked and to be able to then answer them. And the more you understand what the solution you're providing, the more you're able to anticipate some questions that you can be asked so that you can adequately answer them. And the other thing that I will say is that Lord Denning said that God forbid that a lawyer should know all the law, right? Yes. And what God should not forbid is that the lawyer will not know where to find the law. So sometimes you might be asked a question that on the spot you might not have an answer, right? And it's okay to say, this is what I'm getting from this question. I will provide an answer subsequently. So sometimes you might not have all the answers, but you might have an idea. You put your idea and then you take the time to actually say, okay, this is what the question is. And then you do your research and you come back stronger. So there will be opportunities to present these solutions in different fora. So be prepared and be ready for that. So the idea of this hackathon, when I conceived of it in 2014, it was just an idea, but I'm so excited about all the enthusiasm that you all brought to the table. I am really proud of all of you for the effort that you've put in, working with teams that are not just in your cohort, but working with people in Malawi, working with people outside UP. That's really a dream come true for me personally. So thank you so very much. And that is it. Thank you. There's some refreshment outside. Okay. I have gifts for our judges, which I will present to them now. Thank you so much. Thank you so much. And then I also have a certificate. I'm global this year. I have a certificate for certificate of appreciation. The certificate of appreciation. Thank you. Thank you. And then I said that I will give a gift to the first person to arrive here today. And the first person that arrived here today is Seppo. So, thank you so much for your diligence. Yes. And that's it. Thank you, everyone. Thank you to those online. Thank you as well. We appreciate your being here with us and staying the course. Thank you to Tiamo and to Omega, right? Yes. And Joseph for also being part of the team. And I forgot to announce that the winning team actually has a cash prize. In the sum of 15,000 rands. And the runner-up has a prize of 5,000 rands. So I will email each of the teams for how to access your cash prizes. So you just complete the UP claim form and then the prize will be paid into your account. And each of you will receive a certificate of participation from us via email before the week is over. Thank you.